Hello, this is Matt on the Moon Lambeau channel. There are new indications that Ripple CEO Brad Garlinghouse may be positioning to settle with the SEC. Now, keep in mind that there are three defendants that the SEC are going after. It's not just Ripple, but it is Ripple CEO Brad Garlinghouse, and Ripple co-founder Chris Larsen. So, even if indeed this does end up being the case, and we end up seeing a settlement between the SEC and Brad Garlinghouse, that doesn't mean that Ripple is off the hook here. But there are a couple notable attorneys within the XRP community that have been talking about this very topic, including attorney John Deaton, although he didn't specifically broach the topic of settlement for Brad Garlinghouse, more so about the legal occurrences that have been brought up over the last day or so. But attorney Jeremy Hogan, he actually did kind of hint at this, and so I'll show you all of the specifics because it is interesting what's happening right now, and specifically the timing. But I do want to be clear at the outset, I don't have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just a simple little Moon Lambeau doing Moon Lambeau things, making YouTube videos all up on the internets, but it's only a hobby, just to be clear about that. And so attorney James Filan, who is another attorney within the XRP community, does what he keeps on to do. He's been doing for, I guess, over half a year at this point, which is updating the XRP community with all of the latest legal filings. He's been quite diligent, and I'm very thankful, and I'm sure everybody else in the community is as well. And so you can see he shared this. XRP community SEC vs. Ripple. Defendant Brad Garlinghouse files motion to obtain international discovery, which led to articles like this one from Cointelegraph, and I do want to run through a couple parts of this article. This is titled Brad Garlinghouse's Lawyers File Request for Binance Documents in International Challenge to SEC Lawsuit. The lawsuit between Ripple Labs and the U.S. Securities and Exchange Commission, or SEC, now involves major crypto exchange Binance after a recent filing on behalf of Ripple CEO Brad Garlinghouse. And actually, let me pause here because I want to make sure everybody understands this before we go any further. The idea of Brad Garlinghouse having sold his XRP in markets outside of the United States and to non-United States citizens, like that case has already been made. I want to be super duper clear about this. And this is important because the SEC doesn't have jurisdiction over sales in foreign territories that aren't sold to United States citizens. And so you'll see the implications of this as we go through, but I just wanted to be clear about that. This argument has already been made, but it's super relevant considering this most recent legal filing. So anyway, Cointelegraph continues. According to court documents filed in the Southern District of New York on Monday, Garlinghouse's legal team has requested documents relevant to the case and unobtainable through other means from Binance Holdings Limited, the Cayman Islands-based subsidiary of the major cryptocurrency exchange. The filing cited United States laws concerning the Department of State and the Hague Convention and asked the court to issue a letter of request for the central authority of the Cayman Island to compel evidence from Binance. And here's a quote. Mr. Garlinghouse seeks foreign discovery on the basis of his good faith belief that Binance Holdings Limited possesses unique documents and information concerning this case, and specifically concerning the process by which transactions in XRP allegedly conducted by Mr. Garlinghouse on foreign digital asset trading platforms were conducted, said the filing. And so I think it's pretty obvious that Brad Garlinghouse sold the vast majority of his XRP, assuming that's a true statement. I have no reason to think it's not, but he likely sold the vast majority of his XRP on other platforms specifically for this reason, presumably under the advisement of some sort of legal attorney, like I don't even say legal attorney, just attorney, the advisement of some sort of attorney, which makes sense because you never know. Like even though it's his XRP, as far as we're all concerned, I think we pretty well all agree he can do whatever the hell he wants with his XRP, but by selling it in other jurisdictions. If he's advised, hey, the SEC can't come after you if they decide that they want to go after Ripple, which would be stupid, and this would protect you to some degree. To me, that makes all the sense in the world. But anyway, the piece continues now. Specifically, the lawyers seem to be challenging claims from the SEC that The Ripple CEO sold more than 357 million XRP tokens on worldwide crypto trading platforms to investors all over the world. The team cited Section 5 of the Securities Act of 1933, and this is relevant, listen up, which states that the alleged illegal XRP sales applied only to domestic sales and offers of securities. The documents requested of Binance may contain evidence in support of that claim. And here's a quote. As the SEC knows, Mr. Garlinghouse's sales of XRP were overwhelmingly made on digital asset trading platforms outside of the United States. The discovery that Mr. Garlinghouse seeks will be relevant to demonstrating that the offers and sales that the SEC challenges did not occur in this country and are not subject to the law that the SEC has invoked in this case. Highly relevant indeed, is it not? And so now, take a look at this. My fellow XRP YouTuber, Jungle Inc. on Twitter, wrote the following. So Brad is pulling his own trading records, and the SEC does not object. What is this about? Yeah, why isn't the SEC have any sort of beef with this? Well, there's a good reason, and attorney John Deaton jumped in and stated the following, explaining, the SEC can't object and not look awful before Judge Netburn. The SEC used MOUs, that's Memorandums of Understanding, to seek similar information, and when the defense objected, claiming that the SEC sought was what the SEC sought was one-sided, the SEC argued to the judge that the defense could seek out the information this way. Yeah, so indeed they would look a little bit two-faced. I mean, they are two-faced, but still, that the judge would think that presumably. And so what he's referencing here with the Memorandums of Understanding, it goes back to when basically the SEC was shaking down Ripple's foreign customers and other partners. You may recall that because the SEC has partnerships with governments the world over, basically, that are set up in such a way that they can basically demand information from businesses that are not in the United States, and then so those businesses that the SEC doesn't have any sort of direct control over, obviously, they get shaken down from their actual government. So the information flows from the business to the to their government to the SEC, basically. And so they made legal filings to make this all happen, and the judge allowed it within this case. And so now here we have something that structurally you could say it's somewhat similar, although in this case this isn't to damage the SEC, whereas with the SEC, what they were doing, it seemed really like an intimidation tactic. So I thought it sounded shady anyway. But Jungle Inc. then responded with the following. I guess my question is, since they are his trading records, can't he just print them out? Which is a good point. You can go on to pretty much any exchange I've ever used anyway, and you can see all of your transactions. It's not hard to do. So why is he requesting specifically from Binance this information that presumably Brad Garlinghouse himself could easily get at any moment? Well, John Deaton responded with the following. 1. Receiving records this way provides self-authentication, etc. And 2. I imagine they need more complete records to show the other end of the transaction was not within the jurisdiction of the United States. And so there you go. It's coming from an official source this way, effectively. And it proves the receipt or the finality of the transaction outside the jurisdiction of the United States. So this should offer certainty that what Brad Garlinghouse is claiming is true, where there would be perhaps question marks if he's just logging into his Binance account and saying, hey, here are the records, I just printed them up. So that makes sense. I can understand that. So that's good insight from attorney John Deaton. Now you have a Jeremy Hogan, attorney within the XRP community, retweeted the document share from attorney James Filan and wrote the following. Garlinghouse is getting documents from Binance related to his sales of XRP to it. This request goes to our third issue in the case, which is jurisdiction over the sales. SEC cannot disgorge profits to foreign entities or individuals. These documents will fight damages. Now, here's where it gets very interesting, so I'm glad you've stuck around to this point. Somebody on Twitter named CryptoBoom wrote the following. For those concerned that this means there are no settlement talks, you need to understand the information being requested would be needed to further a settlement agreement. Well, how about that? That's fascinating. And Jeremy Hogan wrote the following. That is correct. I mean, I can't comment. I mean, no comment on the correctness of what you just said, smiley face. So obviously he's being a little playful about it. I like it, but excuse me, but But yes, Crypto Boom seems to be absolutely correct, according to Jeremy Hogan, that you would need this for a settlement. Now, that in and of itself, you might be like, okay, but there's all sorts of documents you could need for settlement. But it's actually even more relevant than that. Consider this. Here was a comment on Twitter from somebody named XRP Hutch, who wrote the following. Doesn't anyone find it odd that it took 7 months for this action by Brad's legal to take place? You mean to tell me they just thought of this in the last few days? Really? And then Jeremy Hogan wrote, holding my tongue. So why did they, after 7 months roughly, why now are they going this direct route, if not for the possibility of settlement? That's exactly why, right? So this is the speculation within the community. I think it's perfectly reasonable speculation. In fact, take a look at this. This is another tweet from my fellow XRP YouTuber Jungle Link. Brad Garlinghouse has already filed to have his case dismissed based on fair notice. If that's the case, it doesn't matter who he sold his XRP to. Then why is he now requesting these records? He knows it won't ever get to the fair notice issue. Settlement is in. Exactly, and so if he was really heavily counting on the fair notice defense to take care of all of this, then you wouldn't necessarily need to acquire these records. So the fact that this is happening right now, especially in light of some of the other recent developments, including comments from SEC Commissioners Hester Peirce and Elad Roisman about when they were talking about CoinSchedule, you may remember that case, and they made it very clear that there never has been and currently is not sufficient regulatory clarity from the SEC within the space. Well, that's damaging to the SEC's case for sure. It's very damning. And so there's that, and there have been some other developments I've been covering on the channel as well that are noteworthy, and so it's all coming together right now to this moment where it's out of the blue. Otherwise, if it's not this, like out of the blue, why 7 months later is Brad Garlinghouse's legal team going after this? And so then somebody named AE Crypto responded to Jungle Link and wrote, if settlement is in, why go through the trouble to produce these transactions? And Jungle Link wrote, as others have said today, this info will be used to calculate the settlement amount. And that makes all the sense in the world because they're not claiming, Brad's legal team is not claiming on his behalf that no sales were made to in the United States or to United States citizens. Now, Ripple itself, Ripple the company, hasn't sold to any retail users, but Brad Garlinghouse specifically, it seems as though he likely has. But again, the vast majority of sales would have been outside the United States. So if there's a settlement here, don't be surprised if he ends up owing something. But this will not be the end of the world. This should be just fine. So it'd be good to get one of the defendants' situations completely settled. It'll be interesting to see, too, if we see a similar filing for Chris Larson in the not-too-distant future, given that a lot of these types of filings, especially given the nature of the attack against Brad and Chris, a lot of the responses have been along the same lines and at similar times. So it was interesting to me kind of that, we only saw something from Brad's legal team. But don't be surprised again if we see something from Chris's too. I would not be surprised if when Chris Larson sold his XRP that he went a similar route just to protect himself legally, which to me is just a smart move. Why? Because look, even though you're not doing anything wrong, you know that the SEC can come after you making bogus nonsense claims, which they have done. And so, so hopefully they both received such advice and acted accordingly. And it looks like the answer is yes to this point, at least for Brad. So let me know what you think, but I'm going to wrap up here. I am not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.